I sent you to life in confinement without parole.
That's f***ing horse shit. You do whatever the f*** you want.
Why are they shutting my mic off?
I'm the federal witness of the United States federal government. I demand some goddamn respect, you. All I did was trespass on property.
Ma'am, you gotta create the community that you want to live in.
I have created a Patreon page for those of you who want to support my channel. All patrons will receive access to the new private bond court Discord server. All video content will remain on my YouTube channel for free. Supporting me on Patreon is not required, but it is greatly appreciated. Thank you to everyone for watching my channel, liking my videos, and leaving comments. Bond court is now in session.
It's a public hearing. You've been in custody since what, November 1st or October 31st, somewhere around that time?
November 16th.
November 16th. And you have yet to be provided a lawyer, is that correct?
Yes, sir.
Okay. What I'm going to do, Ms. Hurd, is I'm going to grant a bond of $10 for each charge that you have. And now there are fees and other things that may be added. But in my opinion, it's ridiculous that you've been in jail this amount of time and you've not been provided legal counsel, even though you are entitled to that. So I'm going to have to go back through your file, and there's going to be a stay away provision put on your bond as to the person who's the alleged victim in this case. So you're not going to be allowed to contact that person. You're not going to be allowed to go around that person, any of friends or family of that person. Do you understand that, ma'am?
Yes, sir.
I'm sorry, I had to take a moment. I don't know the breakdown, but this is not the way things operate in America. And whether you're guilty or innocent of this charge, I don't know. That's the whole process that's going to play itself out. But you should not be languishing in a jail without a lawyer or someone advocating on your behalf. You're still entitled to a lawyer. And my understanding is that those requests were signed saying that you should have a lawyer. But I'm not going to allow you to sit here while people who have jobs that are supposed to do the things of appointing people to represent you are not doing their jobs. Now, the state of Georgia, they still have a case that they may proceed against you. And they have 4 years from the date of the alleged incident to file whatever charges they want to file. And there have been serious charges that have been leveled. So with the conditions that I've placed on your bond, you have to understand, if you violate those conditions, you could be charged with the felony offense of aggravated stalking, and your bond could be revoked, and you could come back to jail.
Mr. Anderson?
So, Ms. Freeman, have I left anything out?
No, I think that's it, Judge. Did you want to give a new date for this one, for that June 27th, or either that Monday or that Wednesday?
I'm going to give the June 27th date for you to come back before me, Ms. Hurd, because I don't know your circumstances. I understand a little. So I'm gonna give that June 27th date as a continuance date. If you are able to post bond, that date will get waived and you will receive a new court date in the mail if the district attorney's office decide that they're going to pursue this case. Do you understand that, ma'am?
Yes, sir.
Do you have any questions?
No, sir.
Okay. Well, you're free to go back, and I'm gonna have to write, honestly, I'm gonna have to do a detailed order because some people may be upset about the decision that I've made today. And so I'm going to explain my reasoning. I'm going to explain the breakdown. It's
And Judge, I think also, I guess after you finish that order, so Ms. Hurd knows that you'll get a copy of that order to her.
yes.
So she'll have a copy of that. Mm-hmm.
Yes, and I'll call over to the jail, or I ask Miss Mary to make certain that she gets that piece of paper to be in her hands. Because ma'am, you still have a uphill battle. Based upon the allegations, and I don't know how it's gonna go, but what's been done to you, in my opinion, is unfair and unnecessary. And it places the state at a disadvantage. It places you at a disadvantage. So, do you have any questions, ma'am?
So when you said about the fine, saying like $10 per charges?
You're charged with 5 charges. Aggravated assault, aggravated battery, false imprisonment, tampering with evidence, and terroristic threats. So that's going to be a total of a $50 bond, but the sheriff's department is required by law to add fees to it. So I don't know the exact number that it's going to be, but it's going to be a little bit more than that. Okay.
Okay.
All right.
All right.
Okay. Okay, ma'am. You're welcome. You're free to go back. Make sure you speak to your family so they can hopefully help you get out of custody. And Miss Mary, we'll put her on the June 27th. Yes.
Okay.
And we'll see what happens. Now we're at the jail. If you can effort to get Miss Moore, please try that. But I know, she's an adult and she makes her own decisions. So we have Officer Austin here, and we're ready for Howard Graham. Can we bring Howard Graham up? Are you Howard Graham?
Yes, sir.
Okay, Mr. Graham, this is your preliminary hearing date. My name is Brad Gardner. I'm going to be the judge presiding over this hearing. I need to just caution you that anything you say here is not privileged or private. So please don't discuss or say anything that you wouldn't want the whole world to hear. And if at some point you need to speak to your lawyer, I'll give you that opportunity so you can have a private conversation with your lawyer about something that may have popped up. For the record, this is State of Georgia versus Howard Graham. Mr. Graham is charged in warrant number 2022 CW 50945 with committing the offense of interference with custody. Mr. Graham is also charged in warrant number 2022 CW 50946 with committing the offense of computer pornography and child exploitation. Mr. Graham is charged in warrant number 2022 CW 50947 with committing the offense of rape. He's charged in warrant number 2022 CW 50950 with committing the offense of trafficking a person for labor or servitude. I don't have a charge.
There's no, I don't care if it's a world here. I do know my
Mr. Graham, this whole thing is being recorded. You can unmute him. You can unmute him. Mr. Graham, it's in your best interest to remain silent. You have a lawyer that's going to protect your interests. Everything here is being recorded. Everything that I'm telling you right now are allegations. State has proved these allegations beyond a reasonable doubt. Just if you got, it would be in your best interest if you have a contention about a label, speak to your lawyer about it. Talk to your lawyer about it. Don't try to talk yourself out of it, because, sir, whatever you've been able to say or do at this point still has you behind bars in a jail. So don't try to talk yourself out of this. But you have, and I'm gonna tell you this, and I'm gonna shut up. It's my job to give you the opportunity to speak, and that generally is done when you have a lawyer. Is you speak through your lawyer, because your lawyers went to law school. Your lawyer knows what to say or not say. Because if you start engaging me in a conversation, Mr. Graham, I've been a lawyer for 22 years. And if I start asking you questions, it may not turn out well for you. Okay, sir?
I just like, I understand. I'm not trying to disrespect you, Your Honor. I'm really not. You know what I'm saying? It's already difficult for me to hear this stuff anyway. And I know I feel like I have a right. I have a right to speak, and I have a right to defend myself. But at the same time, I know this is preliminary hearing. I understand your job. I don't mean no disrespect, but I feel like I have a voice. It's my right to have a voice, because I feel like a lot of the allegations that's put against me are some are false. You know what I'm saying? And it's true.
So, Mr. Graham, the thing that I tell people in first appearance hearings and preliminary hearings, everybody that has gone to trial and been found not guilty go through the exact same process that you're going through right now. So the allegations are the allegations, and you have a right to defend yourself. But you're at a point now where your lawyer doesn't even have the whole case file from the state with whatever evidence and statements and things of that sort. And your lawyer is going to be asking those questions today. So how about it's better to see, as what I would say, what they are saying about you. You see what they're saying about you, and you sit down with your lawyer and you say, this ain't right. This didn't happen this way, or I was here on this date, or I was here on that time. Right now, if you start talking, you're going to repeat the same things that got you arrested in the first place. So but it is your choice. And I'll give you that choice, and your lawyer can't stop me from giving you that choice. And if you want to do it, you can do it. But for warrant number 2022 CW 50970, I don't have a charge listed for 70.
It's cruelty to children in the first degree.
Okay. And then finally, it's warrant number 2022 CW 50971. Nope, it's not finally. 50971 charges child molestation, and 50972 statutory rape. So, Mr. Howe, I understand it's hard to hear these allegations, but I have to at least state the case so that we can get into a posture where we can have a hearing. Okay, sir?
Yes, sir. I understand.
Mr. Graham is here represented by Ms. Pleasant, and Ms. Freeman is here representing the state. Mr. Freeman, would you please swear in your witness and present your case?
Thank you, Your Honor. Can the jail be muted first?
Yes, I'll mute them.
Detective Austin, would you raise your right hand, please? Do you swear and affirm that testimony about to provide in the matter of State of Georgia versus Howard Graham will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please tell us your name and how you're employed.
Detective Michelle Austin, Clayton County Police Department as a detective in CID, and I've been here for 8 years.
Since working with the Clayton County Police Department, were you assigned a case involving the defendant Howard Graham?
Yes, ma'am.
Okay. Please tell us how this investigation came about.
So on February 24th, Clayton County Police Department dispatch received a call from the victim's mother. The victim's mother, who was located in Topeka, Kansas, called stating that her daughter had gone missing days prior and had called her on that date saying that she wanted to come home and that she was being dropped off at a Dollar General or Family Dollar in the Clayton County jurisdiction. Officers responded and found the victim at the Family Dollar, made contact with her, and at that point they were alerted that a sexual assault had taken place and that she was in fact the missing child out of Topeka, Kansas. That's when
How old was the child?
13.
She was 13 at the time?
Yes, ma'am.
Okay. And were you able to confirm her identity and date of birth with her mother?
Yes, ma'am. So her mother had friends and family that are here in the Clayton County area, church members, and they were able to come make contact. We were able to confirm the identity of the child and bring her over to have a forensic interview performed.
What did the forensic interview indicate?
Well, the victim disclosed during a forensic interview of meeting the suspect online. The suspect advised the victim that he was 18 years old. While they were online on a game app, the victim was asked by the suspect to meet him at a different chat room on a different app, according to the victim. She went into this app's chat room, and at that point, they began exchanging information. The victim gave the suspect her address. They were supposed to get together. This happened, I believe, on a Wednesday or a Thursday. That Sunday, the suspect drove from Clayton County to Topeka, Kansas, and picked the victim up from her residence and brought her back to Clayton County. The victim stated that en route back to Clayton County from Topeka, The suspect took the SIM card out of her cellular device and destroyed the SIM card and threw it out the window. When they arrived back here to Clayton County, there was sexual intercourse, oral and vaginal intercourse that took place at the suspect's residence on 3 different occasions. The occasions would have been the 21st, 22nd, and 23rd during the time that she was in the custody of the suspect.
Okay, stop for 1 second. I know, Ms. Freeman, you probably know this, and Detective Austin, you probably know this, but for all intents and purposes, because it's a young victim, I don't want there to be any kind of identification of the victim. Okay.
Yeah. Right. That's why. Right. Detective Austin has just referred. We've just said the victim, and she's given her age. So.
Yes.
Detective Austin, from your investigation, were you able to confirm the residence or any of the information that this juvenile victim gave?
Yes, ma'am. So after the forensic interview was concluded, we sent our police social worker from Clayton County along with another officer. The victim was able to lead them back to the residence. Later investigation of the residence found that our suspect was, in fact, a resident of that residence. I then put together an ops plan, and we were able to get a search warrant for the residence. During that time, we had officers watching the residence. The suspect left and at that time went to work, and he was actually picked up from work. We decided that it would be a good idea to just grab him from work. So we were able to confirm the residence, everything that the victim described inside of the residence up to a music studio inside the residence. We were able to confirm during the search warrant of the residence. And later on, of course, I don't know if we're there yet, but we were able to interview the suspect, and he did agree to interview with us after Miranda was read.
And when you say the suspect, who are you referring to?
Mr. Graham, Howard Graham.
Did the defendant make any admissions during this interview?
Yes, ma'am. The defendant made multiple admissions during the interview that was audio and video recorded, and did write an apology letter at the end of the interview to the parent.
What admissions did he make?
He made admissions to first kissing the victim that took place as soon as he picked the victim up. And then he made admissions to having sexual intercourse with the victim during the time period that the victim was in the residence.
And just to make sure, when we say sexual intercourse, can you describe exactly what that means?
Mr. Graham admitted that he did have penile to vaginal intercourse with the victim. I believe, if I'm recalling it correctly, he did deny that he had the oral sex with the victim, but stated he did have vaginal to penile intercourse with the victim.
Did Mr. Graham admit to going to Kansas to pick up the victim?
Yes, ma'am. Mr. Graham did admit that he met the victim on in the chat room. He met the victim on the child gaming site and invited her to the chat room. He admitted that he did tell the victim at the time he was 18 years of age. He admitted to going to pick her up from her residence. At some point during the interview, he did finally admit to destroying the SIM card. He stated it was the victim's idea to destroy it. He admitted to bringing her back to the residence, and he admitted to sexual intercourse.
Detective, after the juvenile victim had her forensic interview, did she also have a medical exam to determine if there were any injuries to her?
Yes, ma'am. She did have a medical exam and a forensic interview, though.
Did the medical exam reveal any injuries to her?
It was not trauma, but there was, according to the person that did the forensic, there was signs that some kind of sexual intercourse had taken place, but nothing trauma was revealed during during the medical.
Was there, or did the victim indicate whether or not anyone else was in the home of the residence while she was there?
Yes, ma'am. While she was in the residence, she met 2 roommates. According to the victim, during her forensic interview, she stated that her and Mr. Graham had already come up with a plan on the way back from Topeka, Kansas. And the plan at the time was if she was questioned by any of the male roommates, she was to tell the male roommates that she was his daughter. And at one point, Mr. Graham left, the victim assumed to go to work. And she went to one of the roommates, a male, and told them that she was hungry. And the roommate then told her, you know, talk to your father when your father comes back. And the victim got upset and stated, that's not my father. And that's how the roommates were alerted that the victim was actually not a relative of Mr. Graham, and that it was someone that, you know, an unknown person that he had brought into the residence.
Were officers able to identify these roommates?
Yes, officers made contact during their search warrant on their end with the roommates. I do not have their names up front, but they did make contact at the residence.
Do you know whether or not those roommates corroborated what the juvenile victim has stated?
Yes, the roommates did corroborate that the juvenile victim had been in the residence for a few days.
Detective, the actual sexual intercourse, where exactly in the home, or did the victim say exactly in the home where that occurred?
Yes, ma'am. She said the sexual intercourse occurred in Mr. Graham's bedroom.
Do you recall the address of the defendant's residence, Detective?
The address, I actually wrote it down on my notepad if I can look at it. The address of the residence, 6394 Waikiki Way.
And is that in Clayton County?
Yes, ma'am. Forest Park, Clayton County, Georgia. It's Forest Park.
During the victim's forensic interview, did he indicate whether or not the defendant, did he purchase her any items while she was here in Clayton County?
Yes, ma'am. So we did go back to the Family Dollar. The reason she knew how to give the address to the Family Dollar is because when they entered Clayton County from, you know, during their travels, that was their first stop, was to that specific store. He did purchase her, I believe she said it was a hoodie and some other items from that store prior to going to the incident location. He also purchased her some food during the time that she was at the incident location as well. I believe she said it was like a burger place or something that was in the area of the residence.
And Detective, from your investigation, what date was the victim taken from Kansas?
She would have been taken from, first contact was made on February 17th, and she was picked up on February 20th from Kansas. The morning of February 20th.
And just so we're clear, did Mr. Graham have the permission of her mother to take her from Kansas and bring her to Clayton County?
No, ma'am. No contact was made with the parent. The victim left the house with a small bag of clothes, and got into the car, and the parents were not aware the victim was leaving the residence.
The apps that were used for this communication, do you recall what those apps were?
Yes, ma'am. The first, I don't know if I can say it on Zoom. The first app was a Roblox app, which is a popular app among kids. So it was, the first contact was made on Roblox. There was a message sent through Roblox, and it asked her to come over to an app called MILF.com. And it's a private app, of course, and they have chat rooms. And so that's where she began to communicate more with him as far as making arrangements for the pickup and drop off and everything. That took place on MILF.com.
Have you been able to secure any records from those apps?
No, ma'am. Unfortunately, I went on leave for 10 weeks right after the arrest. So I have not been back. So that's why the case file is still open. I need to do search warrants on a couple of other things before I close it out.
Did the victim give any kind of details or description of the actual sexual intercourse?
She did, based on the age, she didn't give a detailed description like we would as an adult. However, she did say that the forensic interviewer, once she admitted to sexual intercourse, asked her questions with an anatomical drawing, questions to the effect of, did his penis, what's the penis, go into your vagina? And she was able to confirm that the penis did go into the vagina. She is also the one that made the outcry of oral sex as well, which would have been his penis to her mouth.
Did she indicate whether or not it was painful or not?
She did not indicate whether or not it was painful.
I withdraw.
Or I'll say question has been withdrawn. I muted myself. I apologize.
I believe that's all I have. Thank you, Detective.
No problem. Thank you.
Ms. Pleasant?
Thank you, Your Honor. When did the forensic interview take place?
The forensic interview took place on the day that the call came out. So I'm sorry. The forensic interview took place on 2/25 because the call for the road officers came out on 2/24 at 10:30 p.m. So the forensic interview took place hours later. They actually, what's the word I'm looking for? They called the Rainbow House out. So they activated the Rainbow House and they came in first thing that morning and performed a forensic.
And who conducted the interview at Rainbow House?
If I don't know if you want me to look at my case file, I can tell you if I look in the case file, I have it at the top.
If that's going to refresh your recollection, please do.
That is going to be Nikisha Wykel.
Nikisha, say the last name again.
Wykel, W-E-I-K-E-L, Nikisha.
Okay. And who conducted the interview with my client?
I did.
And on what day was that conducted?
That was conducted on 3/1/22.
And you said Miranda was read to him?
Yes, ma'am. He signed Miranda.
Okay, so you have a signed form that's been entered into evidence.
I have a signed form that's with the case file right now. The case file's been locked up because I went out right after we arrested him.
And was this interview, was it memorialized in any way?
I'm sorry.
Was the interview memorialized in any way?
Was the interview recorded?
Audio, video?
Yes, it's audio, video. Yes, audio, video is saved on our drive. Yes, ma'am.
Now, precisely how was the alleged victim able to make contact with her mother in Kansas?
I'm not clear on how she made contact. We got the 911 call from the mother in Kansas. It's unclear how she made contact. I believe during her forensic interview, and I can review it, she said that the roommate allowed her to use his phone while Mr. Graham was out of the residence to contact her mother and tell her mother that she would be dropped at the Family Dollar at a specific time.
Okay, you said dropped. How exactly did she get to the Family
Mr. Graham
Dollar?
brought her to the Family Dollar. According to her, he was not on scene when officers arrived. It was just her on scene. And according to the victim, Mr. Graham brought her to the Family Dollar. And when the officers arrived, lights and sirens, it startled Mr. Graham, according to the victim, and he pulled away before the officers pulled in.
So just to be clear, the alleged victim went along with Mr. Graham freely from Kansas to Clayton County.
Yes, ma'am.
And there have been no allegations that she did anything against her will.
The only allegation that she made against her will was when he destroyed her SIM card and threw it out the window. She's stating that she did not agree to that and that he took the phone and took the SIM card out and threw it out the window. Also, when they were in the residence, when he left for work, she stated he left for work. He told her she could not leave the residence.
And you previously testified on direct that you had a search warrant that was executed for the residence, correct?
So yes, so the initial plan was to do an ops plan just in case, because we had multiple people in the residence and we could not identify who was who outside of our suspect. So I put together an ops plan because we were going to do a search warrant with SWAT to be on the safe side the next morning. However, Mr. Graham was spotted because we do surveillance for 24 hours leading up to the search warrant. He was spotted leaving the residence and going to his employment. It was the decision was made that due to us not knowing how many people were in the residence, we were going to take him directly from his place of employment. So the warrant was executed after Mr. Graham was already in custody.
What, if anything, was recovered through the search warrant?
I would have to go back through. I know there was some audio and video because the victim had stated during her forensic interview that there was a recording studio in the house and that at some point she was allowed to record on a song. So the audio and video from the house was retrieved. There was bedding that was retrieved from from Graham's bedroom, along with, I believe it was a gray hoodie, one of the gray hoodies that we were trying to find on the video camera from the Dollar General. But I would have to go through the entire inventory sheet to give you the rest of the items that were taken, because unfortunately I was here interviewing Mr. Graham. I was not on scene when the search warrant was executed.
But to your knowledge, a large amount of, if there was recovered.
Yes, ma'am. It's at least an inventory sheet. Yes, ma'am.
And you just said that there's video from Dollar General. Is it Dollar General or Family Dollar?
It's going to be, let me just look. I always get the two confused. It's going to be Dollar General on Tower Boulevard. I don't know if you need the numerics for that. And no, we were not able to get any of the video captured. They lose it after a certain amount of time. And like I said, I went out right after the arrest. I was out.
Okay, so what did you observe on the video at that time?
No, I did not go out to get the video, is what I'm saying. Once the arrest, yeah. I sent detectives out to the Dollar General, and at the time they could not access the video. They needed management to access the video. And then right after that, I went out. So I don't think there was a follow-up. I would have to check RMS to see, but I don't think
nothing at all was observed on the video at Dollar General?
No, ma'am. According to the detectives, nothing was observed on the video at Dollar General.
Okay. And did you execute a search warrant for DNA in this case?
Yes, ma'am.
And who was that on?
DNA was collected during Mr. Graham's interview. He had a copy of the search warrant. I went to the jail with him, and there was DNA collected, of course, during the rape kit for the victim when she went to the Rainbow House.
So if anything with regards to the bedding?
Nothing for the bedding. They will not, Georgia Bureau of Investigation will not test the bedding until something comes back with the DNA. Like, we have to have a match of some sort between the suspects. So there's a whole procedure. So the bedding right now is in evidence.
And if you would take a brief moment and tell me what else you have in evidence that was seized from the residence.
Okay, you want me to go in the case file?
Yes, please.
Okay. Okay. Okay, so from the residence is a black and color iPhone with a gray cover. One silver and color MacBook Pro. One, let me know if I'm going too fast. I don't know if you're writing this or you just went on the record.
I can hear it. Yes.
Okay.
Go ahead.
One silver and color MacBook. One blue and silver in color flash drive. One bag of clothing. One letter. Lettered gray and blue blanket. That's the blanket the victim described sleeping on or having sexual intercourse on. One black and color female boy short panties. Black and color Nike tracksuit. Black and color computer. Black and color hard drive with WD initials on it. Gray and color hard drive. Black and color Sony camera. Black and color Canon camera. Black and color Sony RX. Gray and color Metro PCS cellular phone. Two black and color PNY. I would have to go on the RMS and see the description of exactly what that is. One black and silver flash drive. Two red and color spiral notepads. One silver and color Apple monitor. One black and color Sony HD. And Cameron, handheld camera. One Roblox gift card. One black and color Samsung cell phone. One black and silver and color HP computer. One gold and color necklace with letter H pendant. One bag of female miscellaneous clothing. One blue and color blanket. One gray and color washcloth. One green and color blanket. One black and white and color fitted sheet. One black and color Apple iPhone Pro Max. And then there's a separate inventory sheet, of course, for the buccal swabs that were taken from him at the precinct.
Okay, thank you.
No problem.
Now, you testified as well that he had roommates. How many roommates?
Yes, ma'am. There's two males who also lived in the residence.
And they've been interviewed with regards to the alleged victim in this case.
The only interviews were the brief interviews that took place on scene by officers. It should be on body cam. Officers were on scene during the search warrant. So the detectives that went on scene questioned them. It was brief questioning about whether or not the female was in the residence and when she arrived to the residence, when she left the residence.
And that was the interviews were both roommates or just one?
Yes. I believe it was both roommates. I'll go back and look. It was done. It wasn't done here at the precinct. It was done when the search warrant was executed. So that was done by separate detectives.
And those would, you said that, would they be on body camera?
They should be on body camera. We always have to have one officer on scene during the execution of a search warrant. So that officer should have had a body camera on, yes.
Okay. Thank you. That's all I have, Your Honor. Thank you.
I just had one follow-up, and I think it's because I wasn't clear on the response. No, that's okay. I knew you were muted. Yes. Detective, I believe Attorney Pleasant, correct me if I'm wrong, I think she asked you a question during her examination regarding if the victim indicated that if whether any of these acts were against her will?
Yes, ma'am, that's what she asked.
Okay, and what was your response to that?
It was not against her will.
And so regarding that, what did the victim, what did she indicate in response to being asked that?
I'm sorry.
If you're stating that the victim, are you saying that the victim stated it wasn't against her will?
No, it was never during her forensic interview, because they interviewed her, and she never made a statement that anything was happening against her will as far as her getting in the car, her going to the residence. She never made an outcry that anything was against her will during her forensic interview.
Okay. Okay, well, and based on that, and you took out a warrant for rape, is that correct?
Yes, due to the age.
Okay. You took out a warrant for statutory rape and rape, is that correct?
Yes, ma'am.
Okay. When the victim was in the house, and it, just because I know the testimony, we've heard a lot of testimony, just trying to be clear, was the victim able to leave the residence when she wanted to?
No, ma'am. According to the victim, she was told when he left for work, and like I said, I'm not assuming, but this is what the victim is saying, he left for work, that she was told she was not to leave the house. At one point, the victim stated during her forensic that she was told to stay in the bedroom when the suspect left the house. But at some point during a 3-day interaction, she was allowed out of the bedroom, and that's how she ended up in the roommate's music studio.
Okay. Judge, I believe that's all I have.
Okay. Ms. Pleasant, do you have any follow-up?
No, Your Honor.
Okay. So may Detective Austin be excused, Ms. Freeman?
Yes, Judge, and the state waives opening.
Okay. Detective Austin, thank you for your patience. You are free to stay and listen to the end, but if you have something else to do, you're also free to go, ma'am.
Thank you, Judge.
Okay, Miss Pleasant, before we get to the argument stage, your client has been animated, and if he has a statement to say, I'll give him that opportunity. But before I do that, I want to hear your viewpoint on whether your client should make a statement or not.
He absolutely should not make a statement. It's not in his best interest. And I would ask to be briefly placed into a breakout room with him to remind him of the conversation that we previously had.
Okay. Can we unmute Mr. Graham? Mr. Graham, and please don't start talking. You've heard from your lawyer as to her position as to whether you want to make a statement or not. You have to understand that if you start wanting to make a statement, I would have to place you under oath, and the state will have an opportunity to cross-examine you about anything that you've said. But the right to provide testimony is a personal right that belongs to you and you alone.
Well, I have one thing to say.
Wait. So that's what I gotta say, Mr. Graham. Once you start talking, you open the process up to stuff that Ms. Freeman can't make you say, I can't make you say. But once you voluntarily enter into that arena, you open yourself up to dangers. Because if I have a question about anything that you say, I'm going to ask that question. If Ms. Freeman has a question about anything you want to say, she's going to ask that question. So do you want to at least speak to your lawyer first before you say anything?
I do, but I'm not I'm not making any missions on camera because of whatever.
Mr. Graham, and the reason I'm stopping you is people tell me all the time, well, I'm not saying that, you know, I did this, but I did do that. And
no, I'm not saying that.
Stop, please, sir, please stop. And they unknowingly make admissions. So I think what I'm going to do is I'm going to pause this and I'm going to give Ms. Pleasant an opportunity to speak to you about whatever it is that you want to say, and it'll be in a private room. So you can lay it out to her chapter and verse and get her advice. And I would encourage you to accept her advice of whatever she says to you, because she actually went to school for this and paid a bunch of money for it.
Understood.
So I'm gonna pause it here. I'm gonna place you in a breakout room. Miss Freeman, I saw Miss Pass and Miss Rockwell come back on. So, okay, Mr. Wilson, this is your preliminary hearing. My name is Brad Gardner. I'm going to be the judge presiding over the hearing today. And I just want to caution you that nothing you say here is privileged or private. So please don't say anything that you wouldn't want the whole world to see. If you need an opportunity to speak to your lawyer, I'll give you that opportunity to speak to her in private. Do you understand that, sir?
Yes, sir.
Thank you. For the record, this is position number 120, State of Georgia versus Rashard Wilson. Mr. Wilson is charged in warrant number 2022 WA 08241 with committing an offense of criminal trespass. Mr. Wilson is also charged in warrant number 2022 WA 08242 with committing the offense of aggravated assault. Mr. Wilson is represented here today by Ms. Hill. State is being represented by Ms. Freeman. Ms. Freeman, you can swear in your witness and start your examination.
Thank you, Your Honor. Officer Angeles, would you raise your right hand, please? Do you swear and affirm that the testimony about provide in the matter of State of Georgia versus Rashard Wilson will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, I swear.
Please tell us your name and how you're employed.
Officer Angeles, I'm employed Clayton County Police Department.
Okay, you can lower your hand. How long have you worked with the Clayton County Police Department?
I've been working there since December 14, 2019.
So when you worked with the Clayton County Police Department on May 17th of 2022?
Yes, ma'am.
And on that date, were you dispatched to 4737 King Saul Drive in Rex, Georgia, in reference to a domestic violence call?
Yes.
When you arrived at that location, who did you meet with?
I first met with Miss Wilson.
Is that Shelly Wilson?
Yes, ma'am.
And is that the mother of the defendant, Rashard Wilson?
Yes.
And what did Miss Shelly Wilson tell you that happened involving her son, Rashard Wilson?
Ms. Wilson advised me that she told Mr. Wilson, her son, originally that to pick up the cigarette butts that he has been leaving on the yard for the past couple of weeks. And then a verbal argument started from that point.
Who was the verbal argument involving?
The verbal argument first started with his mother, Miss Wilson, about the cigarette butts.
Did the verbal argument, did it escalate?
Yes, after the verbal argument between Mr. Wilson and his mother, it started to a property damage after he punched a hole on the wall.
Is this the wall of the residence belonging to Miss Shelly Wilson?
Yes.
Were you able to see the hole?
Yes, ma'am.
And based on what Ms. Wilson said and your observation of it, was this damage less than $500?
Yes.
Now, at the time when this happened, Was the defendant living at this home?
Correct.
Who all lived in the home?
To my understanding, it was Mr. Wilson, Miss Wilson, and her boyfriend, Mr. Shellman.
Did Miss Shelley Wilson, did she own the home?
To my understanding, yes.
And at the time, did she give her son, Rayshard Wilson, permission to punch a hole in the wall?
No, she did not.
What happened after Mr. Rayshard Wilson punched a hole in the wall?
After that incident, Mr. Wilson walked towards the kitchen area where she encountered Mr. Shellman and started a verbal argument with him.
At this point, they were in the kitchen?
Yes.
At this time, officer, tell us who all was in the kitchen.
At this point, Mr. Wilson, Miss Wilson, and Mr. Shellman were all in the kitchen area. The bedroom connects to the kitchen, which is just one room next to it.
And when you're referring to Mr. Shellman, is this the boyfriend of Miss Shelley Wilson?
Yes, ma'am.
And I just want to be clear, because do you have your report in front of you?
Yes, I do.
Okay. And you completed a WAA regarding Mr. Wilson, is that right?
Yes, I did.
And so in that WAA, did you reference Mr. Shellman as the individual's name?
I cannot recall. Let me look at my report. I'm sorry, Mr. Denham is. So that's gonna be a correction. His name is Larry Denham.
Okay, so just so we're clear, the name of the boyfriend of Miss Shelley Wilson is Mr. Larry Denham.
Yes.
Okay, and so again, tell us who all was in the kitchen at this time.
So it was going to be Mr. Wilson, Mrs. Wilson, and Larry.
What happened when the three of them were in the kitchen?
Once they were in the kitchen, according to Miss Wilson, Mr. Wilson got into a verbal with Larry, telling him that if he has to leave, then he has to leave too. At that point, Miss Wilson advised that Mr. Wilson was trying to fight Larry, in which she intervened and got in between both of them.
What exactly did Mr. Rayshard Wilson do?
At this point, according to Ms. Larry and Miss Wilson, Rayshard picked up a kitchen knife next to the sink, raised it up towards Larry, placing him in fear of receiving bodily injury at that time.
Did Mr. Wilson make contact with anyone with the knife?
No.
You had stated earlier that Miss Shelley Wilson got in between Mr. Wilson and Mr. Denham. Was she able to get the knife away from her son?
Yes, according to Miss Wilson, eventually Mr. Rayshard Wilson put the knife down as Larry walked out the back door.
Were you able to retrieve the knife?
The knife was, I took a picture of the knife that was attached to my report. I did not retrieve it for evidence in this case.
Was Mr. Rayshard Wilson still at the residence when you got there?
Yes.
Were you able to get a statement from him?
Not from Mr. Rayshard. I was only able to get his verbal, but not a written statement.
And what was the verbal statement that Mr. Rayshard Wilson gave you?
Mr. Rayshard, he told me that Miss Wilson came into his room and laid the cigarette butt in his bed. At that point, she unplugged his game system. So in anger, he admitted to punching the wall. He did not admit or did not say, he advised that he did not pick up a knife after the argument with his mother.
Was Mr. Denham still there when you arrived?
Yes, ma'am.
I'm sorry. Officer Angeles?
Yes, ma'am. Can you hear me?
Yeah, you were breaking up some. Was Mr. Larry Denham still there when you arrived?
Yes, he was.
And was he able to give you a statement?
Yes.
What did he advise that happened regarding Rashard Wilson and the knife?
Mr. Denman advised that Mr. Wilson and his mother were involved in a verbal argument in which he walked to the kitchen area and Mr. Wilson approached him, trying to fight him, at which point he pulled a knife out from the kitchen area, and then he walked out the back door. Mr. Denham did advise that Mr. Wilson did charge him with the knife.
Hold on one second. I heard charge him with the knife. Was that charged at him with the knife?
Yes, Your Honor, according to Mr. Denham.
Okay, thank you. Thank you.
Did all of this happen in Clayton County?
Yes, ma'am.
Thank you. No further questions.
Ms. Hill?
Thank you, Judge. Let's see, Officer Angeles, you advised that Mr. Denham claimed that Mr. Wilson was trying to fight him. How did he say that he was trying to fight him?
Mr. Denham, originally, when they got into the kitchen, Mr. Wilson he didn't advise as to any type of body language or anything like that, but he just gave me a statement that he was trying to fight him, in which the mother, Miss Wilson, got in between, holding him back.
I mean, were these verbal statements? Were these, I don't know, physical acts of trying to fight him? He wasn't specific?
No, he was not specific.
Okay. So let's be clear. I want to go back to the knife. So no contact was made with the knife.
Correct.
What about the testimony of Ms. Wilson? Did Ms. Wilson state that Mr. Wilson attempted to stab anyone with the knife?
Ms. Wilson did give a statement where she did advise that she thought Mr. Wilson was going to stab Mr. Denham at that time when he raised the knife up with his hand.
So he raised the knife up. How far was do you know how far Mr. Denham was standing away from Mr. Wilson when he allegedly raised the knife up?
Yes, so according to all the statements, Ms. Wilson and Mr. Denham, they were within about 6 feet apart between the kitchen sink and the rear door.
The rear door. Did they advise of any statements that Mr. Wilson allegedly made while he had the knife raised?
No, there was no statements on Mr. Wilson, on Mr. Denham or Ms. Wilson when Mr. Wilson raised the knife.
Okay, and you said that when you spoke to Mr. Wilson, he stated that he did not pick up a knife. Is that correct?
Right, that's what Mr. Wilson told me.
Okay.
Hold on, I'm sorry. Did I hear the question to be that he said he could not pick up a knife?
He said he did not pick up the knife.
Oh, did not. Oh, okay. Thank you.
So, let's see. All right. So, Officer Angeles, did anyone have a recording of the incident?
No.
There was no recording. Were there any other witnesses to the incident?
No, other than Mr. Denham and Ms. Wilson, other witnesses.
Okay, you're breaking up just a little bit. Let's see. Did at any point did Mr. Denham express that he thought he was going to be stabbed?
He did not. All he told me.
Awesome.
Okay.
Yeah, I'm sure he's going to try to come back because his connection was iffy.
Yeah. Okay, he's back.
You're on mute, and we didn't get your answer, Officer Angeles.
Okay, all right. And what was the question again? I'm sorry.
The question was, at any point did Mr. Denham advise that he thought he was going to be stabbed? You're breaking up again. I'm sorry.
There's Officer Angeles. Your Wi-Fi is getting kind of.
I think it's better now.
Crazy.
Okay, it might be better now. I'm connected to my my vehicle.
Okay, try answering that again, Officer Angeles.
So no, he never mentioned anything about Mr. Wilson or any feeling that he had of being stabbed by him. He just advised that he was being charged with a knife by him, and he walked out the back door.
He walked out the back door. All right. No further questions, Your Honor.
Okay. Any follow-up, Ms. Freeman?
No, Judge. State rest.
Okay. May this officer be excused?
Yes, Your Honor.
Okay, sir, you can stay if you want to the end and hear argument, or you can leave. It's your choice. Ms. Hill.
Thank you, Your Honor.
Do you have any witnesses?
No, Your Honor.
Okay. And Ms. Freeman, I'm assuming you're going to waive opening?
Yes, Judge.
Okay. Ms. Hill, I'll hear from you.
Your Honor, I'm going to ask that the aggravated assault be dismissed. And I ask that it is dismissed because one of the founding elements of aggravated assault is actual assault. And part of that is the apprehension of receiving a violent injury. And it appears that Mr. Denham would have been the alleged victim, and he made no apprehension that he was going to be stabbed with the knife. I mean, if the claims are true that the officer, if the court takes them to be true, he may have picked up a knife, and there's some testimony that it was raised, but not really, it doesn't seem to be much testimony that was thrust at anyone in a stabbing gesture or motion, or that there was an attempt to harm anyone specifically with it. I'm not exactly sure, how that can go beyond to aggravated assault, how that can be bound over, especially when the victim did not believe himself to going to be injured and he was looking right at him. So for those reasons, I ask that the charge of aggravated assault be dismissed.
Judge, we're asking that both charges be bound over. In an aggravated assault, there does not have to be an actual assault or physical assault that happens. The testimony was that Rayshard Wilson charged at Mr. Denham with the knife. That is an aggravated assault. A knife can be a deadly weapon or an instrument that can be used to cause serious bodily injury. So we believe that the testimony is sufficient for aggravated assault. And regarding criminal trespass, the defendant admitted to punching a hole in the wall. It's less than $500. So again, we're asking that both charges be bound over to Superior Court.
So criminal trespass seems to be, relatively straightforward. The aggravated assault, I have a question. I agree with you when it says about the object. My understanding of the statute is the object, when used in an offensive manner, can cause.
It says with a deadly weapon or object that causes or is likely to cause serious bodily injury.
So I agree with you about the object doesn't have to, you don't have to go through the thrusting motion, or in this case with the knife, with the thrusting motion. What I heard was that the person who's the object of the crime was not the person that actually gave the information. It was the Mr. Wilson's mother that provided the information.
Oh, Judge, both of them gave information. Mr. Denham indicated that the testimony was that he stated that the defendant charged at him with the knife. And I think that's when you even asked Officer Angeles to confirm what exactly he was saying.
Okay.
Judge,
yes, Ms. Hill.
An aggravated assault.
And Ms. Freeman, you'll get the last word, but go ahead, Ms. Hill.
I mean, an aggravated assault still requires, that a person commits, they assault with the intent to murder, rape, or rob with a deadly weapon of the sorts. But the assault was allegedly made at Mr. Denham, who did not perceive Mr. Wilson as attempting to harm him with the knife. I just don't see how that can be bound over as an actual aggravated assault if there's no complaining witness to say that they perceived the aggravated assault or an attempt to be harmed with the weapon. So,
y'all made me pull out the book.
Judge, the charging at Mr. Denham with the knife is sufficient for a probable cause for an aggravated assault.
Which I did hear that testimony. But the way
but Your Honor,
Judge, at this point, I'm gonna object now because Ms. Hill has made her argument and has had 2 opportunities to speak. I have made my argument. I've had 2 opportunities to speak, Judge. At this point, I think is now up to Your Honor. And again, because the state gets the last word, and I certainly object to Ms. Hill being able to add anything additional to her 2 arguments that have already been made.
No, and Ms. Freeman, I will always give the state the last word. At this point, as you've, I guess, figured out for me, if I have a question, I want to talk about it with both parties and try to figure out what's the right thing to do. Give me 1 second. So Ms. Hill, I'm looking at 16.521A2. When a person assaults with a deadly weapon or with any object, device, or instrument, which when used offensively against a person is likely to or actually does result in serious bodily injury.
Yes, Judge.
But
the key word, I'm looking at the key word as an assault. So when did the assault actually occur?
Judge, again,
hold on, Ms. Freeman.
Judge, it's just we're going through the same thing, and I think again, is Ms. Hill has made her argument, and Judge, and I think that Ms. Hill is, she's talking about the perception of fear, and that's a difference in reasonable apprehension. And again, she's made her 2 arguments. I've made mine, Judge, and I think at this point, all arguments should be closed.
Ms. Freeman, arguments are never closed. and you're winning this argument. Because Ms. Hill, I'll tell you this.
Yes, Judge.
The way that I'm reading the statute, if Ms. Wilson observed Mr. Wilson move towards the other guy, the alleged victim, that what she observed or perceived would be sufficient to meet the elements of aggravated assault, whether the alleged victim knew that it was coming or not coming.
Perhaps, Judge, but I mean, there was no testimony that there was an attempt to injure anyone. And I mean, charging at someone, even with the weapon, unless there was an attempt to use the weapon, I don't think would constitute an assault. And I mean, you can charge at someone with a knife in your hand, but unless you're pointing it and waving and attempting to stab someone, you're not really assaulting
them. I think the language of the statute that says is likely to, it brings the whole thing into play. So if I'm holding a baseball bat, whether I swing it at you or not, I'm holding that in a manner that could cause an assault upon you. So I'm going to bind both of these charges over to the Superior Court of Clayton County. And thank you, Mr. Wilson. And Ms. Wilson can be sent back. And thank you, Ms. Freeman and Ms. Hill, for engaging me in edification. Now, Mr. Wilson, I've had a couple people today that want to talk. I'm telling you, it's your right to be heard, but it's not wise. So, do you want to be heard or not?
The officer is on for Bruce.
Okay. Okay, Mr. Wilson. Could you unmute Mr. Wilson at the jail? Mr. Wilson, if I hear you starting to get into anything about the facts of your case, I'm going to shut you down, okay? Because you need to speak to your lawyer who's trained to have these discussions and understandings. So, what is it that you want to say to me, Mr. Wilson?
Thank you, Your Honor, for giving me a moment to speak on my behalf. That's what I like to say, first of all. Second of all, I just wanted to say, basically, in the heat of an argument, when the phone call was made.
Oh, stop. You're getting dangerously close to saying stuff about the facts of your case that may lead to admissions. So let me tell you this. I understand it's family members, stuff happens, all of that kind of stuff. This is not the place or time to discuss that and hash that out. Okay.
The only other thing I have to say to you, Your Honor, is, sir, that due to the fact of the case that I have at hand, and I have no other family members in Georgia to even commit to try to bond me, because due to the fact that they're on the bond, sir, I have no chance of trying to be able to get out and actually get a proper way to handle this case, sir. Those are, my mom is the only person I have. So in all light, I just want to ask if there's any way that I could have a chance to be able to fight it
from not in the jail walls because I have no family here. That's my mom is my only family in Georgia.
So, Mr. Wilson, that is a possibility, but that's a discussion you need to have with your lawyer first about how to try to maneuver and move through this whole thing. Because I have to tell you, Mr. Wilson, from my perspective as a judge, the person that has you in custody right now, based upon what I heard, is your mother. And I don't know what you were doing or allegedly doing or whatever. So as something, it can happen, but it's something that's gonna have to go through a process of a two-way communication. And two-way communication is you, your lawyer standing by your side, and the alleged victims. And there's testimony and there are things that are said, and people can be tested about what they're saying or not saying. So I would encourage you to stay in contact with your lawyer, listen to your lawyer about ways that this matter can be resolved. Because there's something that's called the Crime Victims Bill of Rights. And what that means is that if your lawyer today filed a motion to have your bond reviewed, the state gets a minimum of 10 days to contact the people who are the alleged victims so that they can be present. So it's a process. And you have to understand that, sir. Okay?
Okay, and okay, we'll continue.
Okay, well, your case is going to get moved over to Superior Court. Your lawyer is going to keep working on your behalf to try to do what they can do. And all I can do is wish you luck. Okay? All right, sir. You are Mr. Wilson is free to go back. And
Thank you so much.
You're welcome.
You're welcome. You're welcome.
And Ms. Freeman, you said that Mr. Bruce.
Yes, Judge, and I think Attorney Rogers, if he could have I think he wanted a breakout room to speak to Mr. Bruce briefly before we start.
Okay, I can do that. And Mr. Rogers, I received a message from Ms. Freeman about Mr. Craig.
Yes, sir. Yeah, I'm familiar.
Craig, I'm sorry, an officer involved. So that case is gonna get continued. And we can, I'll speak with Miss Mary about the date